Good morning, folks. It's Andy Stautz at Stautz Law. Today, I'm back with another talk about a common estate planning question, or it's really a kind of an estate administration question. And that is a handwritten will, or what lawyers call a holographic will. Holographic is just a fancy legal term for handwritten. So a lot of times you'll see this for people who maybe don't trust lawyers and they want to do it on their own. So they'll, write out their own will. They were probably more common back in the day before you had computers and you could just print stuff all the time. Or someone maybe in their last illness, they don't have time to do formal things. And, they've got maybe a notebook or a diary and they write a page in their diary saying, I want the house to go to so-and-so. And so the common question is, okay, well, in Indiana, are holographic wills valid? Is a handwritten will valid in Indiana? And the answer to that is a handwritten will is not special in Indiana. So it's valid if it meets the other requirements for validity. That means it has to be witnessed, and signed. If there's a self-proven clause, great, but I've never seen one on a handwritten will. So it doesn't matter. Your will does not need to be printed on fancy paper. You can handwrite it, but you still need two disinterested witnesses. Unlike some other states, some other jurisdictions, or way back in the day, the fact that it's in your handwriting alone is not enough to prove, to make it valid, to prove that it's yours. So that really trips people up a lot. If you go into probate and you say, well, mom left everything to so-and-so, it's like, well, there's probably a moral obligation or an equitable obligation, that was her last wish. But, last wishes that aren't embodied in documents, valid documents, aren't going to hold up in court. So on the planning side, that's a big oopsie, right? That's a disaster. You wanted something to happen and it didn't work because you didn't do the legal formalities. And it leads to lots of conflicts too, because then you've got, the person with the handwriting in their favor, they're not going to get along with the intestate heirs. That is, the people who get the property if there is no will at all. So you're asking for trouble. But short answer to the question, a handwritten will in Indiana is valid only if it meets the other requirements for validity. Nothing special about handwriting. There's a tiny exception for, like immediate death, like battlefield situations, but that's not relevant pretty much ever. So I think that's all I had to say on that one. It's just kind of a cautionary tale. Don't assume that because it's in handwriting that it's going to be valid. Just the cost of the probate, much less the fighting it causes. Doing a little bit of planning ahead and making sure you've got your documents is going to forestall this, so that we don't have to deal with this question in your estate. That's all I've got for today. Thanks for watching, and I hope it's been helpful. You can call me or book an appointment online if you want to talk about this or any other estate planning or estate administration topic. Thanks. Bye.